Hello everyone, welcome to our presentation. Our topic is about insider trading. Here comes our agenda. First we will talk about the definition and concept of insider trading and the types of insiders. And then we will talk about the market misconduct and the civil or criminal offense about it. Fourth, we will talk about the defenses against a charge of the insider trading. Hope you enjoy. What is insider trading? There are three types of insider trading activities. They are 1. Dealing, 2. Concealing or procuring, 3. Disclosing relevant information directly or indirectly. A statement of when insider trading takes place is given in Section 270 Securities and Futures Ordinance. To simplify, insider trading may take place in the following situations. First situation, the connect person possesses relevant information and use it in dealing or getting others to deal, or disclose it to others knowing they would utilize this information. 2. In takeover situations, knowledge of the takeover becomes relevant information and is used by the connect person for dealing or procure others to deal. What is relevant information? Relevant information is a specific information in relation to the corporation. If it were generally known to the people, it would be likely to materially affect the price of the securities. Connect persons. Connect persons include 1. Directors, employees, or substantial shareholders of the corporation. 2. Persons who have access to relevant information by reason of having a professional business relationship with the corporation. Listed securities. Listed securities have been expanded to include unlisted or unissued securities in gray market and during IPO roadshows. Gray market usually refers to the trading of new issues before formal admission to trading, and the roadshows are presentations to potential investors in advance of a new issue. Who are insiders? An insider is a person who is in possession of the information which he knows is relevant information. There are 4 categories of insiders. First, persons who may be described as internal primary insiders. They are individuals who have a private relationship with the corporation. It is a private relationship which gives them access to the relevant information. Second, persons who may be described as external primary insiders. They are individuals who have an official relationship with the corporation. It is the official relationship which puts them in the privileged position to receive relevant information about the corporation. Third, persons who are thinking about making a takeover. Fourth, persons who have received tips with regard to the relevant information from any of the 3 categories of insiders above. This category of person is usually referred to as secondary insiders. Now let's have a look at market misconduct. There are 6 forms of market misconduct. 1. Insider dealing. 2. False trading. 3. Price rigging. 4. Disclosure of information about prohibited transactions. 5. Disclosure of false and misleading information. 6. Stock market manipulation. All 6 forms of misconduct are subject to civil remedies, and all 6 forms may be punishable as a criminal offense. The Securities and Futures Commission, having completed the investigation, will make the initial decision as whether there is sufficient evidence to punish the market misconduct under the civil or criminal laws. As for civil cases, the Securities and Futures Commission will refer civil cases to the Financial Secretary, who will decide if the civil proceedings should be instituted by the Market Misconduct Tribunal. The Securities and Futures Commission will refer criminal cases to the Secretary for Justice, who will decide whether the criminal prosecution should be brought before the court according to the Department of Justice prosecution policy. The 2 basic factors should be considered are 1. If there is sufficient evidence. 2. If it is in the public interest.
Now I would like to introduce some defenses against a charge of insider trading. 1. A person can argue that he engaged in a trading for the sole purpose of acquiring or qualifying shares, or in the performance in good faith of his functions as a liquidator, receiver, or trustee in bankruptcy. 2. A person can also establish that he engaged in the trading not for the purpose of making a gain or avoiding a loss. 3. A person can argue that He is an agent who does not have knowledge of any insider trading activities, and also he merely carried out the instructions of his principal. 4. The person can argue that the corporation has Chinese wall practice. Then 5. The person can establish that he is engaged in transactions which were not needed to be recorded on the stock market, and the other trading party also knew the information in question. 6. When a person is charged with an offense through his concealing or procuring another person to a deal, he can argue that the other person did not conceal or procure another party to deal, and also the other party knew he was a person connected with the corporation. 7. The person can establish that the transaction was a market contract. 8. A person can argue that the dealing was under consideration or in the course of a series of such dealings, and the purpose was to facilitate the transaction, and also the relevant information was market information arising directly out of his involvement in the transaction. Then 9. For the trustee, he can argue that he acted on advice from another person, and the other person appears to him to be an appropriate person to seek the advice, and also the transaction appeared not to be an insider trading. 10. The person can also argue that the transaction was by way of his exercise of a right to subscribe for those listed securities, and also the right was granted to him before he became aware of any relevant information of the company. That's the end of our presentation. Thanks for watching.